Hello everyone, I'm Ankit and you're watching StudyIQ English. In our today's video, we'll try to understand why is Forest Rights Act of the year 2006 in news currently. And the reason why we have picked up this particular topic for our today's discussion is very clear. Now on May the 8th, the Port Blair bench of the Calcutta High Court, it was hearing a matter, right? Now in this matter, the Calcutta High Court's Port Blair bench, it agreed to hear a public interest litigation which was filed by a former secretary to the Union government, Mrs. Meena Gupta. Now, in this PIL, Mrs. Meena Gupta is alleged that the government, while it took consent of the tribals for implementation of the Great Nicobar infrastructure project, the government has allegedly violated the Forest Rights Act. The official name of Forest Rights Act 2006 is Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Rights Act 2006. So in our today's discussion, we'll first try to understand what all rights are given to the tribals through the Forest Rights Act 2006, and then only we'll be in a place to understand now whether the central government has actually violated this act or not. Okay, so this is what we are going to understand, and the notes which I will be using in our today's session, these are very important for your prelims, so you should go ahead and download them by going to a Telegram channel called as ATS Live. And while you're at this channel downloading the notes, please do not forget to subscribe to the channel as well. Okay, so let us first understand what is the background issue here. As you can understand, the government is implementing an 81,000 crore Great Nicobar Island project. In this strategic project, where the government wants to increase the reach of Indian Defence Forces as well as the government in the Great Nicobar Island, which will allow it to project a larger power in the broader Indian Ocean region. So here the government is constructing an integrated township. It will also construct a transshipment container port. It is also going to construct a solar and gas based power plant which will provide power to all these infrastructure projects, and most importantly a greenfield dual use airport. This dual use airport is projected to cover both military as well as civilian aeroplanes, right? So these are the sum total of projects that the government is undertaking in the Great Nicobar Island, which you can understand is ecologically a very sensitive area. So to undertake this project, first the government needs permissions of the local tribals like Nicobarese, Shompens, etc., who inhabit this area, and they are entitled to some rights under the Forest Rights Act. So according to that Rights Act, the government needs their permission, their consent before it can start construction of these projects. Now, while this case was filed in the Calcutta High Court, the central government actually raised preliminary objections regarding whether this PIL is maintainable or not. And the petitions they have filed in the Calcutta High Court saying that the reduction of the buffer zone of the Galathea National Park as well as Campbell Bay National Park, in addition to the matter of consent under the Forest Rights Act, they have been violated by the Union government. So the objections that the Union government raised in order to allow for maintenance of this PIL or not, that was overruled, and now the Calcutta High Court's Port Blair bench is going to consider this case. So in our today's discussion, let us first start by understanding what is a Forest Rights Act. The intention or the objective of Forest Rights Act was to provide or to undo the historical injustices that the forest dwelling communities have faced at the time of colonial rule over India, and even after the end of colonial rule, after the enactment of the Indian Constitution, there was no such recognition of the rights of forest dwellers that was present in the Indian Constitution. So, by enacting Forest Rights Act, the government wants to provide land tenure to the forest dwelling communities in order to ensure them their livelihood as well as provide them with food security. Now, the agency that is responsible for implementation of this Forest Rights Act is the Ministry of Tribal Affairs of the Union government, not the Ministry of Environment, Forest and Climate Change, please remember. And at the state level, it is overseen by Department of Tribal Welfare at the state level. So these are the nodal agencies that implement the Forest Rights Act. Now, what kind of rights are entitled to the forest dwelling communities as per the Forest Rights Act? Let us understand this. Sum total, there are 13 rights that are available, which can be divided into 4 separate categories. The first category is called as the title rights, also the ownership rights. In these, the tribal communities are given individual forest rights. So the individual forest right, it grants ownership of the land to a tribal farming family as of December 13th, 2025. Now, how much amount of land are these tribal families entitled to? This is maximum of 4 hectares per family. Now, what are the conditions on which they will be granted these rights? Are these granting them rights over new land? The answer is no. They are not being granted rights over new land, only those lands that they were farming as of December the 13th, 2005. Now, the ownership rights entitles the tribal families to pass on these lands to their own children, which means the rights here are hereditary in nature. However, on the other hand, these rights are neither alienable nor transferable, which means these tribal communities, these forest dwelling communities, they will not be able to sell this land to a non-tribal family, right? So this is what title rights means as under the Forest Rights Act. In addition to title rights, FRA also provides use rights. Use rights for what? Use rights for minor forest produce. Now, what are minor forest produce? Minor forest produce are resources of forest, every resources except the timber resources, which means the tribal communities are not entitled to the wood of the forest. Rather than that, other byproducts like the bamboo trees, honey wax, medicinal plants, tendu leaves. Tendu leaves are the leaves which are used to make beedis, right? So the tribal communities, the forest dwelling communities, they are entitled to collect, use, dispose of all the non-timber forest produce. In addition to that, the forest dwelling communities are also entitled to right to grazing areas, that they can take their cattle and graze them into the forest area, and it also provides them with access to water bodies for fishing as well as domestic use purposes. So these are use rights. Use rights for what? Minor forest produce, forest resources for grazing purposes, and water for grazing as well as domestic purposes. In addition to that, the third category of rights are relief and developmental rights. Here, the forest dwelling communities have a right to alternative land and rehabilitation in cases of illegal eviction of the land or forced displacement. Suppose if any developmental project has been created over a forest land, these forest dwelling communities will be compensated by the government, and they will also be provided an alternative place where they can set up their homes. In addition to that, the forest dwelling communities also have the right to divert forest lands for community facility purposes, but here there is a limitation. They can only divert up to 1 hectare of land. And what are these community facilities that they can construct over these lands? They can construct schools, dispensary, fair price shops, roads, electricity lines, etc., which may involve felling of trees not just more than 75 trees per hectare. So this is a restriction over which the forest dwelling communities are provided with relief and developmental rights. The last category here is probably the most important category, that is the community forest resources. Now, the ownership of this community forest resources are granted to Gram Sabha, where the Gram Sabha has the right to protect, regenerate, conserve as well as manage any forest area that has been traditionally vested with the forest dwelling communities. Now, what is important about this? This community forest rights shift the powers from the erstwhile forest department, and all of these rights are vested now to locals who can discharge them via their meeting that is called as Gram Sabha. Okay. Now, what or who all are entitled to these rights? Okay. Now, the entitlement of these rights are vested with 2 different categories of people. First are forest dwelling scheduled tribes. These are members of scheduled tribes who reside and depend on forests for their livelihood. In addition to these forest dwelling scheduled tribal communities, even the other traditional forest dwellers have the entitlement of these rights. Now, who are these other traditional forest dwellers? These are basically people who have resided and have been dependent on forest for as much as 3 generations, and 3 generations here means 75 years, and up till when this 75 years will be calculated, it will be calculated up till December the 13th, 2005. Now, these were the peoples who are entitled to the rights. Now, who will grant them the rights? Will the government grant them the right? The answer is no. It is the responsibility of the Gram Sabha, which is a statutory authority which will initiate the process of determining what will be the nature of the rights granted, and how much of these rights will be granted. So these rights are entitled to forest dwelling scheduled tribes and other forest dwellers, and who will provide them and who will recognize these rights? It is the Gram Sabha. Okay, now let us try to understand what is the process of implementation of FRA. As I told you, it is the Gram Sabha at the village level which has the right to receive, verify and consolidate all the claims that have been made by the forest dwelling scheduled tribes and other forest dwellers. And Gram Sabha will pass this to the consideration of subdivisional level committee. Now subdivisional level committee, SDLC, has the right to examine the recommendation which has been passed to it by the Gram Sabha, and it will review the claims and evidences, and this will be passed to the district level committee. District level committee is the final authority for approving and rejecting the claims and issuing of the forest rights title. And the most important cog in this wheel would be the state monitoring committee, who monitors and supervises the implementation of Forest Rights Act, and it reports this progress to the Ministry of Tribal Affairs of the Union Government. So this is the implementation authority. Gram Sabha receives and verifies your claim, passes on to SDLC. SDLC examines the claim and reviews the claim and passes on to the DLC. DLC is the one which is the final authority to provide you or to reject you the right, and they will also be the one to grant you the title of rights. Okay, now let us try to understand what were the allegations have been made in order to say that the Union government has actually violated Forest Rights Act. So let us understand what are the petitioners saying that. Now petitioners are saying that first of all there has been non-settlement of the forest right claims, which is very essential before the diversion of forest should take place. Now as per the Forest Rights Act and the 2009 rules framed by the Ministry of Environment, Forest and Climate Change, the forest lands cannot be diverted until or unless all the existing forest rights claims have been identified and settled by the Gram Sabha. And this plea, which has been filed by the former Union Secretary Mrs. Meena Gupta, they contend that since not a single forest rights have been claimed and settled in the Great Nicobar Island, therefore the diversion of this land is basically a violation of the FRA. So this is the first violation that they have alleged. Now what is the second violation? Second violation pertains to the composition of SDLC, that is the subdivision level committee. Now the SDLC, which examines the claims of Gram Sabha, which I told you before, it is mandated that this SDLC should consist of at least 2 out of 3 members who should belong to the scheduled tribe, and out of these 2 members, 1 should definitely be a woman. Now the petitions have alleged that the SDLC, which was constituted by the Andaman and Nicobar Island administration, it only consisted of 1 tribal member who was belonging to Nicobarese tribe. Therefore this requirement was not fulfilled, and therefore any permission given by SDLC would be in violation of FRA, right? So this was the second violation. Now let us talk about the third violation. As I told you, the recognition of the rights needs to be given by Gram Sabha, and before undertaking any project in the region, you need consent of tribals. And who would give you this consent? It is the very Gram Sabha that will give you the consent. Now for provision of this consent, for the construction of the Great Nicobar Island project, consent was given by 3 Gram Sabhas located in Campbell Bay, Govind Nagar and Lakshmi Nagar. Now the petitioners have alleged that these Gram Sabhas were essentially a settler panchayat committee which was constituted as per provisions of Andaman and Nicobar Panchayat Regulation Act. So these are essentially communities meant for non-tribal settlers. So they did not have the power to grant you the consent which you require under the FRA Act. Since these committees have no rights under FRA, so consent provided them have no legal standing whatsoever, and therefore it is the third violation of the FRA which was alleged by the petitioners. Now let us talk about the fourth violation. This fourth violation consists of consent given by the Nicobarese tribe. Now, as against the consent given by Nicobarese tribe, here the consent was given by the chairperson of the Nicobarese Tribal Council, and it has been alleged that the chairperson is not legally entitled to give consent on behalf of the entire committee. And even if the consent was given in November 2022, the council chairman and the captains they formally revoked this consent. So the consent as far as Nicobarese tribe was concerned, it was wrongfully taken, and even if it was wrongfully taken, it has been taken back. So the consent of Nicobarese tribe have not been given to the government, and this is the fourth violation of the FRA. And talking about the fifth violation of the FRA, here comes the issue with respect to consent given by the Shompen tribe. Now Shompen tribe, which is endemic to the Andaman and Nicobar Islands, they are largely uncontacted tribe, and they are semi-nomadic in nature, and they practice hunting and gathering in order to meet their food requirements. Now the consent that was obtained on behalf of Shompen tribe, it was given by an officer of the Andaman and Nicobar Janjati Vikas Samiti, which itself is a government body. So here comes the issue of conflict of interest. Government is taking the consent, and who is providing the consent? Not the tribes, but an officer of the government who represents the tribe. So what is the violation here? The violation here basically becomes that the consent itself is fundamentally illegitimate. On what grounds is it illegitimate? Let me explain it to you. Now the Shompen tribe, they cannot read or write any language of the administration. So they cannot understand what will be the proposal that has been presented to them. Now even the consent or the concept of giving consent to any such kind of project, this entire concept is alien to the tribes that are Shompen. And in addition to that, even the tribes who are uncontacted in nature, they have right to self-determination. So it is up to them to give the consent, the matter of consent, which is already inalienable. So this consent on their behalf can't be given by a proxy of the government, which not just is a conflict of interest problem, but it also raises the problem whether you give right to self-determination to any tribe or not. So these are the grounds on which the Great Nicobar project have been protested against. Now, although this project itself is very geostrategic and geoeconomic in nature, but gradually there are many roadblocks that have been created. So what do you think? Are these roadblocks genuine, or are they created based on vested interest of other countries who we are trying to rival by construction of Great Nicobar project? Do let me know in the comment section, okay? And we will try to solve 3 questions that have appeared in UPSC exam. But before that, there is a very important announcement that I need to make. The topic that I just covered deals very important topics of environment and ecology. To understand environment and ecology properly, you need to take admissions to our resolution batches. In our resolution batches, we cover not just environment and ecology, which by the way is a very important subject of UPSC, covered in both prelims and mains, but all the other subjects that are relevant for UPSC. To take admissions to these batches, just go to our website, and before making the payment, if you apply the code ATS Live, you're going to get maximum discounts. Right now, today we are on 20th of May, and today itself the batches have started. So it is not late. Even if you take admissions right now, you can attend the recorded lecture that happened today, and from tomorrow on you can be present live in the classes, okay? Do not forget, these batches are separate for the students who are looking to give exams in 2027 as well as 2028. So do keep that in mind. If you apply this code, you're gonna get maximum discounts. And let us try to solve these questions. First is from 2023. This is a very easy question. You would be able to solve it if you have covered our today's discussion diligently. A second question which asks you at the national level, which ministry is the nodal agency to ensure effective implementation of the FRA Act. Now there is a third question which is a bit tricky. In 2019, this question was asked: as per the recent amendment to the Indian Forest Act, forest dwellers have the right to fall bamboo trees grown on forested areas. Now this amendment, which was done in 2019, it allowed the forest dwellers to fell bamboo trees in non-forested areas, not in forested areas. Whereas as per the FRA Act of 2006, bamboo is constituted as a non-timber forest produce, and therefore tribals are able to harness these resources. So the first statement is incorrect. As per the FRA Act, bamboo is a minor forest produce, correct, and FRA Act allows ownership of minor forest produce to the forest dwellers, again correct. So 2 and 3 are correct, 1 isn't, so option B is your right answer. Do let me know the answers to these 2 questions in the comment section, and the ones waiting to download the notes, you can go to this particular Telegram channel, ATS Live, and this is where you download the notes. If you have trouble locating this Telegram channel, just scan this QR code, you'll find the same. And also do not forget to subscribe to the channel. So this is all from my side for today. We'll see each other again tomorrow. Please have a very good day.